One after. So.
Good afternoon, learned senior advocates, senior colleagues, and distinguished colleagues. My name is Paul Odam. I am an associate in Simmons Cooper Partners. I'll be moderating our session today. Today's session focuses on a subject that sits at the heart of modern employment practice in Nigeria: probationary employment. A phase that is often treated casually in practice, but has far-reaching legal and operational consequences when mishandled. With evolving judicial attitudes, particularly from the National Industrial Court, probation is no longer a gray area employers can afford to approach loosely. Today's session will be the first in a series of discussions on key clauses in a typical employment contract and how they are interpreted and applied under Nigerian law. Across this series, we will examine these clauses one after the other through the lens of current judicial thinking and practical workplace realities. To take us through this topic, we have a facilitator who combines deep doctrinal knowledge with strong practical experience. Our facilitator is Dayo Bello, a senior associate and team lead for employment law and dispute resolution at Simmons Cooper Partners. Dayo has over a decade of experience advising and representing employers across sectors on labor and employment matters, workplace disputes, and risk management. He is widely published in this area, and his recent work on probationary practices, termination, and unfair labor practices has been recognized both locally and internationally. Recently, Dayo received the Thought Leadership Award from Mondak in 2 different categories. Beyond practice, Dayo brings strong academic grounding, having graduated as best graduating student from the University of Ilorin many years ago, with further specialist training in dispute resolution and employment-related practice. He regularly advises corporate clients on structuring employment relationships in line with current judicial thinking, and this session reflects insight drawn directly from that work. Please join me in listening attentively as he takes us through Onboard or Overboard, navigating the currents of probationary practices in Nigeria. Please make welcome Dayo Bello.
Good afternoon, distinguished learned SEALs, learned senior colleagues, and learned colleagues. My name is Dayo Bello, and I will be facilitating today's training titled Onboard or Overboard, Navigating the Currents of Probationary Practices in Nigeria. In today's training, we will be discussing an important as well as an inevitable clause in a typical employment contract that affects all cadres of employees, whether you are a senior person or you are a junior person in your respective organization, be it private or statutory employment. I'm sure you must have at one point or the other gone through this phase in your employment relationship, or you've just been onboarded or about to, or currently going through this phase. You may want to sit, listen, and grab 1 or 2 things from today's training. Of course, today's training is the object of today's training is going to be knowledge sharing, and in doing that, we'll be considering key decisions from the National Industrial Court of Nigeria, which is the adjudicatory body constitutionally empowered to adjudicate over industrial and employment disputes in Nigeria. And in also doing that, we'll be considering some foreign decisions as well, because these decisions continue to shape our legal jurisprudence in labor and employment matters in Nigeria. And they have legal implications as well for legal practitioners advising their respective clients as well as HR managers. Please, if you have questions or comments, I'd love to see your beautiful comments in the chat box. Please use the chat box, and I guarantee you that the moderator will do a great job by collating these questions, and we'll see how far we can go with the Q&A session. Once again, I welcome you to today's training. Please permit me to share with you my slides for today's training. First and foremost, we will be looking at the meaning and purpose of probationary period in employment contract. We'll be looking at the legal framework for probationary practices. Thereafter, we'll also be considering what happens after probation. This is where the issues around confirmation, extension of probationary practices, as well as the issue of termination of employment contract for probationers. Also, we'll be looking at the principles around deemed confirmation of employment. We'll also be looking whether this principle applies to employers. And finally, we will be making conclusions as well as recommendations. First and foremost, what is the meaning of probation? There is no statutory definition for probationary period in Nigeria. And I love the way Article 2, Paragraph 2 of ILO Convention 158 defines it. By the way, ILO Convention 158 is the popular convention on termination of employment at the initiative of the employer. This is the convention that gave birth to the radical departure from the common law principle of hire and fire, with or without reason. Even when there is reason, the reason can be good or bad, so long as the employer complies with the termination procedure as to notice or as to salary in lieu. That is the position under the common law. But with this convention and looking at Section 254, sub C of Paragraph C of the Constitution, the Third Alteration Act, you will discover that the NIC is constitutionally empowered to apply international best practices in its adjudicatory function. And by virtue of that, the NIC, even though the convention is yet to be ratified in Nigeria, the NIC has, in plethora of cases, applied this convention. So back to Article 2 of Convention 158. You know, Article 2, Paragraph 2 of Convention 158 defines probationary period as a qualifying period in an employment contract, which must be determined in advance and must be of reasonable duration. Keywords there: qualifying period in an employment contract. Secondly, the fact that it must be determined in advance. And lastly, it must be of reasonable duration. This is going to be our anchor definition for today's training. And we'll take these definition, these phrases one after the other. What do we mean by, what does the ILO mean by qualifying period in an employment contract? It typically means that initial period, that introductory phase, the onboarding or induction phase, that preliminary stage, that fresh stage of employment before confirmation of employment. And let me bring it to, I will define it as the honeymoon phase, you know, the fresher stage, you know, in an employment relation. You are new in the organization, the HR manager is trying to get you introduced into the system, and so on and so forth. During this phase, this is where you get to know the do's and don'ts of the organization. During this phase is where you get to also know the workplace culture. During this phase, this is where you get to know, this is where you are acquainted with the internal policies, with the internal workings of the organization. During this phase, there's also a phase of cultural adjustment. What do I mean by cultural adjustment? This is a phase where an employee learns how the organization truly works beyond what is written in the employment contract or the employment handbook, as the case may be. In other words, this is the stage where the employee gets to know the unwritten rules of the organization. You know, some of you may call it office politics, but it is not. Sometimes it is not. It is just some of the unwritten rules that constitute the norms, the culture, the tradition of the organization in question. For example, some of the unwritten rules could be the issues around punctuality as to work. During this phase, you may know that, okay, my employer takes this, the issue of punctuality seriously or not. If the employer takes it seriously, then you may need to adjust. Of course, this is not a ground to excuse, to excuse diligence. That's where the employer does not take it seriously. It is also a phase where, for example, you also learn some things like the feedback system in the organization, whether it is formal or informal, how you relate with your colleagues at work, what are the types of joke you can crack, and so on and so forth. And the case of Ogbonna against Neptune, the Supreme Court defined this phase as being inchoate. Yes, as being inchoate. What does that mean? Being inchoate simply means that although the employment relationship has started, or yes, it has started, but it is yet to attain permanence, it is yet to attain full legal maturity. It is still in progress. It is still forming. And because it is still forming, it has not crystallized, it has not crystallized. And because it is still forming, the employee may not be entitled to certain benefits, which are mostly contractual anyway, based on the capacity of the employer. Benefits like 13th month or sometimes 14th month, benefits like profit sharing, bonuses, leave allowances, housing allowances, and so on and so forth. These benefits are basically contractual. They are not statutory. However, the fact that employees, probationers at this stage are not entitled to certain benefit does not confer on the employer to deny the employee of statutory benefits. Statutory benefits like, for example, your wages, your pension, the national minimum wage, the working hours, the working condition, and so on. And sometimes, let me shock you, sometimes leave, annual leave. And let me shock you again, provided it is contained in your employment contract. I know some Gen Zs will love to hear that. Anyway, so the Supreme Court also went ahead to say that unless the contract of employment requires notice of termination, an employer is not mandated under probationary practice, an employer is not mandated to give notice of termination or salary in lieu. The same principle also applies to employee as well. If your contract of employment is silent on termination, then you may not give notice. But if it provides for termination procedure, then you must go through that procedure. I've seen a situation where the contract of employment is silent on termination. The employee, I think she used a dispatch to, to send the workplace equipment, laptops and all, to the organization and just walk away. We can say morally it's not right, but based on the Supreme Court reasoning in Ogbonna and Neptune, she has simply complied with the position of the law. So there is a myth that probationary period typically applies and benefits the employer. But in the real sense of it, it benefits both the employer and the employee. For the employer, what does it mean? It's all about assessment. It's all about observation. What are they observing? They are observing, they are assessing your competence, your suitability, the fit for purpose for that which you've been employed to do. And it is reasonable because at this stage, all the employer, at the recruitment stage, all the employer, the information the employer has is limited. The knowledge or the information about the employee at this stage is limited. It's limited to what is contained in your CV or your reference check, or maybe based on the interviews, conducted for the employee in question. You can imagine a situation where, for example, a company employs a front desk officer based on strong communication skill, during the interview phase. But during the probationary period, the employer discovered that the employee in question lacks the right attitude, the right temperament, on addressing customers, on escalating issues and all. Even though the employee, is competent, even though the employee is in question might have been employed based on strong communication skills, employer at this stage discovered that the employee lacks the emotional intelligence or the right attitude, towards that job. Also, for employers, it is a stage where it's an opportunity for employers to correct any employment errors. It's an opportunity for them to correct any employment errors. Because like I said, during the recruitment process, the information, the knowledge of the employer about the employee in question is limited. So in the event that the employer gets to know that the employee is incompetent, then it's a window for the employer to correct that employment error. This was confirmed in the case of Crawford against Grace Hotel, reported in 2002. It's a South African decision by the industrial court there, where the court held that recruitment decisions are sometimes made with imperfect information, and that probation allows employers to remedy human error or oversight that only becomes apparent once employment has commenced. For the employees, what does it mean? During the probationary period, for employees is a period they need to demonstrate. It's all about a period for demonstration, where they need to demonstrate their skills, their capacity, their technical competence and suitability for that role. A typical Nigeria employer will ask you during interview phase, during the recruitment stage, oh, can you work under pressure? You said, absolutely. In fact, you even tell the employer pressure is your second name. They will ask you, okay, can you multitask? You say, yes, I can do that. Can you go above and beyond? Then you say that. Those things you stated in your CV, those things you promised your employer at the recruitment stage. This is the point you need to demonstrate those capacities. This is the point where you need to demonstrate those skills. This is the point you need to showcase those technical competence. It is also a period of assessment as well for the employee. What do I mean by assessment? Assessment, you are typically assessing whether the job is suitable for you, whether it aligns or it is compatible with your career goals, and objectives. And also, you are also at this point assessing whether you are satisfied with the job or not. This is the phase you discover all of this. I mean, I have a friend within a space of 2 years, resign, change job up to more than 5 times, 3 months, 4 months, 6 months here, 5 months there. It simply means that the employment, the job was not meeting up with his expectation, It was not meeting up with, it's not compatible, does not align with his career goals and expectations. So depending on the nature of the job, generally in private employment, you discover that probationary period is usually between some 3 to 6 months, or sometimes 12 months, or as the case may be 1 year. But in statutory employment, I mean those in public service, state, federal, or local government, you see probationary period extending to 2 years or 3 years, depending on the service rules of the government parastatal in question. So a typical probationary period usually has 4 key elements. So these elements are, it's the duration. It spells out the duration, the termination process, the appraisal metrics, and sometimes the extension. So these key elements are fundamental, or are usually found in a typical probationary clause in an employment contract. Let's now go to the legal framework for probationary period. In Nigeria, the legal framework for probationary period is purely contractual. It's primarily rooted in contract, and there is no provision for probationary period under the Labor Act, which is the principal legislation on employment, on labor and employment law in Nigeria. So it is basically contractual. And this makes sense because if you go back to our definition under Article 2, you discover that apart from defining it as a qualifying period in an employment contract, the ILO says it must be determined in advance. By determination in advance, it presupposes that probationary period is a negotiated clause. It presupposes that there is a form of consensus addendum, a kind of meeting of mind, an agreement between the employer and the employee. Of course, this is also the position under the UK law. It is basically contractual. However, when you look at jurisdictions like South Africa and Netherlands, you discover that it's a different ballgame entirely. Why am I making reference to South Africa? South Africa happens to was a founding member of the ILO, although at some point they were removed due to the apartheid policy. But at a point, I think in 1994, South Africa was reinstated during the democratic regime in South Africa. So key decisions, wisdom, judicial reasoning from South Africa is key in our discussion. So in South Africa, when you look at, for example, their Labor Relation Act, which is their principal legislation on employment, on labor and employment law issues, there is a code of practice which is made, it's a subsidiary legislation. They call it the Code of Good Practice. made pursuant to the Labor Relations Act. That code, when you study it critically, you discover that it contains a comprehensive guidelines regulating probationary practice in South Africa, particularly when you look at Schedule 8, item 8, I think sub 1 from paragraph A to J or K. You discover it contains a comprehensive guideline regulating probationary practice in Nigeria, in South Africa. For Netherlands, in probationary practice generally must be in writing, and it must not exceed 2 months. It must not exceed 2 months. However, where the contract duration is 6 months or less, you do not need probation. And you can find this in Article 7 of the Dutch Civil Code of 1992. And in 2014, the Dutch Parliament discovered that employers were taking advantage, of probationers, because under the Dutch law, you discover that probationers have less protection when it's compared to full staff. So employers were taking advantage of probationers. That was why the Dutch Parliament in 2014 made that regulation that probationary period in Netherlands must not exceed 2 months. And where the contract duration is 6 months or less, you do not need probation. Let's come back to Nigeria. Notwithstanding the contractual nature of probationary period in Nigeria, what I've found is that, some employers tend to take advantage of this, of the contractual provision. This is what I mean. Under the general law of contract, there's a principle that says parties are bound by the terms and conditions of their contract. And once those terms and conditions are agreed upon, then they are bound by it. As a matter of fact, the court is not duty bound to rewrite contractual terms. The duty of the court is only to interpret strictly and nothing more. So you discover that in practice, some employer tends to take advantage of this contractual provision. After all, it is contractual. After all, the employee in question, agreed and signed the employment contract. So they tend to ascribe or impose unreasonable duration period. Don't forget, I said under Article 2 that the ILO says probationary period must be reasonable. And what do I mean by reasonability? Then we have to travel to South Africa. In South Africa, you discover that their courts there have expounded on this jurisprudence, where in South Africa, to determine whether a probationary period is reasonable in duration, you must consider the nature of the job, as well as the time it will take to assess or evaluate the probationer in question. It is not at the whims and caprices of the employer. The discretion there is not subjective. It is objective. It must be exercised objectively. So you have to consider the nature and the time it will take to assess or evaluate the employee's suitability for that role. I commend to you the case of Yeni against South Africa Broadcasting Corporation. The court actually delved deeply on that in South Africa. Also, when you look at Schedule 8, Item 8, Sub 1, Paragraph D of the Code of Good Practice in South Africa, it contains a comprehensive regulation in that regard. Nature of the work, of the job, and also the time for assessment. Now, bringing it back home, and by way of practical knowledge, I've come to discover that, when in Nigeria, when you want to determine the appropriate probationary period to impose in a contract, sometimes you may need to consider the skills required for that role. You may need to consider the industry practice. What are the industry practice in that industry? Sometimes you may also need to discover the experience, the qualification of the new hirer. Imagine employing someone of 15 years post-qualification experience as an engineer in a private employment, and you are imposing 2 years probationary period in a private employment. I think that is quite unreasonable. So you may find a situation where in going forward, the NIC may start questioning, which they have anyway, they've started, may question the duration for that period. And when you look at the reason for this is that if you ascribe or impose unnecessary or arbitrary probationary period, what you are simply doing is to indirectly, you are indirectly taking away the labor rights, the right to labor mobility of that employee. And when we talk of labor law, we are all talking about rights. You are talking about labor rights. We are talking about international best practice, global best practice, and so on and so forth. For example, a simple job requires shorter probationary period. For example, you employed a receptionist. I don't see a reason why you will give a receptionist 1 year probationary period. 2 months, in fact, 3 months maximum, you can determine whether this receptionist is suitable or compatible or not. But it will be different when you are considering high responsibility or specialized or technical role. For example, a senior manager or a technical engineer. That requires a longer probationary period. And why? Because you need to examine, you need to know the competence of this person. So it may need to take longer period, longer time to do that. Also, when the second leg of reasonability is in relation to assessment. In assessing the probationer, it must be reasonable. While the employer has the prerogative to stipulate the KPIs, what I mean by is key performance indicators or appraisal metrics for the employee in question, is doing that the KPI must be reasonable. You must not set an unreasonable KPIs for the employee. Set performance standard, and sometimes also the assessment of that KPI must also be reasonable. That was the position of the court in South Africa, the Labour Court of Appeal, in ESCOM against Mokoena. We have a similar situation in Nigeria in the decided case of Amanzi against Union Bank, where the NIC struck down the practice. In that case, one of the condition precedent for confirmation of the employee in question was that she must have met 100% deposit target, but the employee in question did not meet up, and the company relied on that fact to extend probation period. But the court struck down the practice of deposit target or deposit attraction and held that it was unreasonable. A practical example, for example, maybe a company, let's say within the past 5 years, the total turnover is less than 500 million. And you employ this particularly in sales industry, for example, and you employ this staff, gave him 9 months or 6 months probationary period, and you gave him or her 200 million target to me. Meanwhile, in the past 5 years, your total turnover is less than 5 million. I think that is quite unreasonable. Also, still on reasonability, the employer also has a duty to guide. You must not leave the employee, to navigate the forest by themselves. It's a period where you need to guide, you need to ensure that you guide this employee so that to achieve satisfactory performance, And during this period, what is required of the employer is to constantly or regularly, evaluate or assess this employee so that they do not wait to the end of or almost the end of the probationary period before they start doing this. So during the course of the probationary period, employers are mandated to constantly appraise the employees in question. I mean, that's the position in South Africa, but we can also borrow that wisdom, and you will see along in the presentation that the NIC has also ruled on that, not directly, but by way of reasoning. You can get that. So after probation, what next? After probation, what's next? This is where, depending on the performance of the employee in question, the employee will either be confirmed or the probation contract, the employment contract will be extended or terminated. So we'll deal with this one after the other. So on the issue of confirmation, employers need to answer the question how, when, and why. How, of course, in writing, typically done by either the line manager or HR manager. They will communicate, confirmation in writing. And confirmation presupposes that the employee in question has done fantastically well, has met the satisfactory performance metrics. On the issue of when do you need to confirm this employee in question? Because in Nigeria, as of today, looking at the judicial thinking from the NIC, the issue of time is now of the essence. It must be done within, on or before the expiration of the probationary period. The case of Oluseun against Allmark Health Services Limited and Amanze against Union Bank established this fact. In Oluseun against Allmark Health Services Limited, the NIC held that allowing the claimant to work beyond the last day of the probationary period, by implication, it means that the defendant, that's the company, is deemed to have confirmed that employee in question. Is deemed to have confirmed that employee in question. In other words, even a day after probationary period, if you come to work normally after one day, a day after probationary period, your employer did not say anything, took benefits of the work done, you carry out your normal activities, continue to pay you salary, even if it is one day after probation period, you are deemed confirmed. And where there is any condition precedent as to, for example, medical examination or medical test, or things like receipt of references or background checks, the NIC in Amanze against Union Bank held that it must be done within the probationary period. Okay, so I know this decision may seem harsh, but how does employers, navigate through this period? Now, it is advisable to do a periodic assessment or evaluation of the employee's performance periodically, and to determine their fate, timeously before the expiration of the probationary period. And there is a good reasoning in this, because during the period of probationary period, it is characterized with anxiety, a lot of anxiety, a lot of uncertainties, and sometimes job security. So the employer must endeavor to evaluate, the assessment of the employee, timeously. Time is of the essence. And why do they need to do this? Why do employers need to do this? Because so that they do not run at the risk of the principle of deemed confirmation. We'll deal with that later on in the course of presentation. And also undue delay of confirmation may be termed unfair labor practice, particularly where the confirmation of employment is a condition precedent to assessing certain benefits, due undue delay may be termed unfair labor practice. Now let's quickly go to the issue of extension of probation. Extension presupposes that the employee in question needs a performance improvement plan or training, to improve his or her performance. Not entirely bad, but the employee in question needs some more training, they need some more improvement so that they will be more suited for the role in question. And when it comes to the issue of extension, because probationary period, because the legal framework for probation is contractual, that the extension of provision for extension must be provided in the contract. It must be provided in the contract. And in doing that, when you want to extend, you must, as employers, you must have at the back of their mind that the aim of extension should be performance improvement and not a scheme or device, to deprive workers of confirmation, job security, or accrued benefits. The aim is for performance improvement and nothing more. However, in the absence of express express provision for extension, there is no room for unilateral extension. In other words, where the contract of employment is silent on extension, the employer in question cannot, under our law, extend probationary period. And by what I mean by unilateral extension, unilateral extension may amount to unfair labor practice, and it may also be taken as an indication of confirmation of employment, So let's quickly go to the meaning of unilateral extension. Unilateral extension can actually occur in three instances. The first instance is a situation where the contract of employment is silent, but the employer in question went ahead to extend the probationary period at his sole discretion. By doing so, it means that there is no legal or contractual basis for that. That was done at the sole discretion of the employer. This was the case in Telec Drugs Co. Limited against ONAPA, decided in 2018, where the Court of Appeal found the extension of probationary period by the company to amount to unfair labor practice. As a matter of fact, in that case, the contract provided for 9 months probation period with termination notice of 2 weeks or payment in lieu. But the appellant, which is the company, deferred confirmation by 8 months and 22 months. That's outrageous, respectively. And the court found that by doing that, the company had, by implication, by its conduct, confirmed the employment of the respondent. Another situation still on that unilateral extension can occur is a situation where, and I see this in practice, where the contract is silent on extension, but at the end of probation, the line manager or HR will obtain the written consent of the employee in question, usually done by way of addendum or a formal letter. After all, the employee, their defense is that the employee signed it. At that point, there is a legal risk, because when you go back to our definition of under Article 2 of ILO, Convention 158, you will discover that the ILO says that the probationary period, including the extension, must be determined in advance. It must be determined in advance. So coming after the expiration of the probationary period and demanding by way of written consent, the consent of the employee in question may raise some issues around undue influence. And because of the unequal bargaining power, in employment contract, that may pose some form of legal risk, for the employer. So it is advisable that you determine extension ahead. It must be determined in advance. Lastly, is a situation where I call it a bad draft. This where the contract shows that it is only the employer that can extend, that has the prerogative, that has the freedom, the free will to extend probation. There must be a consensus. There must be an agreement to that effect. Let me give you an example. And this actually occurred in the case of Nwaguman against Ati Industries Limited. One of the defense of the defendant in that case was that the contract gave them the option to extend probation period at their will, at their option, that it can be extended at their own option. But the NIC said no and struck down that practice. Let's take a look at an example. For example, a probation clause that says probation may be extended for 3 months at the employer's discretion. At the employer's discretion. It's different from a situation where the probationary clause reads, the probation period may be extended once for a further period not exceeding 3 months, subject to the prior written agreement of both parties. Any such extension shall be communicated in writing, stating the reasons for extension, the performance areas to be improved, and the review date for confirmation. So you can compare both drafts. You discover that in the first draft, it only gave the employer the sole discretion, the option to extend probationary period at their discretion. While in the latter one, you find that there is an agreement, there is a kind of a meeting of mind, and how it should be determined between the employer and the employee. So the cases of Telec Drugs against Onopa, Noruwa against Main Street Bank, and also Nwaguman against Ati Limited and others established this fact, established the principle around unilateral extension. Now there's a growing jurisprudence on the fact that there is no longer room for extension of probationary period. And this was found in the case of Nwaguma against Ati Industries Limited and another, where my Lord, Honorable Justice Arowo Shegbe of the NIC Enugu Division held that there is no room for extension of probation period in Nigeria. The fact of the case is simple. In summary, the claimant was employed as a research assistant, and the probation period provided for 6 months and extension for 3 months. So the total maximum probationary period was 9 months. And the defendant in question, after the first extension, kept on extending till, I think, about 17th or 18th month. And after that, terminated the employment of the claimant. So the claimant challenged that action in court. And in arriving at the decision, my Lord held, and I quote, "There is no room for extension of probation period in Nigeria. It is either you confirm or terminate at the agreed period. If an employer feels the employee did not quite measure up to the standard, but could still not terminate the worker's employment because the worker's performance was all the same satisfactory enough to retain him or her, the worker, as by logic, met the requirement for confirmation, and the employer's refusal under such subjective conditions is definitely abusive." So you see a lot of our colleagues canvassing the position based on the authority of Waguman and Artis Industries Limited, that you can no longer extend probationary period in Nigeria. Well, I have my own reservation, because if you look at the facts of that case critically, you will discover that the rationale behind, my lord, I stand to be corrected, making that statement was because the employer in question, indiscriminately, perpetually or kept perpetually or extending the probationary period. After the first 3 months, the employer kept on extending the probationary period till 17th month. So I think that was the rationale behind my lord making that statement, but I stand corrected. But as it is now, that is the position. That is the position. Pending when the Court of Appeal, which is the final arbiter on employment dispute in Nigeria, pronounces it, make a final decision on that, you may want to listen to how to navigate through this phase. So this decision has implication. First one, it's an indication that the NIC is no longer comfortable with the extension of probationary period, because what the court has found is that employers abuse the issue of extension. And it also has commercial and operational consequences for employers as well. Imagine sorting out 5,000 applications to get 50 applicants. And unfortunately, that 50 applicants were unable to meet up with the standard. So that means, and you need to, you may not, by this decision, you may need to excuse or terminate the employment contract of those people, of those employee in question. That means it has some form of operational consequence in terms of resources, time management, and so on and so forth on the employer. So you may need to repeat that process again. And lastly, pending when the Court of Appeal clarifies this issue, it is advisable that for employers that when drafting clauses on probation period, the employers should factor in a possibility of extension. Of course, when doing that, remember the principle we stated around reasonability in terms of duration and assessment. So lastly, on the issue of termination, there is when you want to terminate a probationer, because the foundational basis is contractual, you simply need to just abide or follow the provision in your employment contract and nothing more. And there's a misconception that probationary employment, probationers cannot be terminated during employment. No, they can't be terminated because that period is not guaranteed in law. There is no legal right to be employed for the length of the time of probationary period. Your employer can terminate your employment during that period, provided it is done in accordance with the terms and conditions of your employment. Also, the fact that you were promoted, or you were assigned additional responsibilities during period does not, automatically convert your employment into full appointment. So that is the position of the court in Al-Haji Abdullahi Bala against Nigeria Civil Aviation Training Center. That's the position of the court. So let me take a pause here. You know, when you look at our national practice and some of the decided cases in Nigeria, particularly when you look at cases like Ogbonna and Neptune, cases like Albishak and National Productivity Council, and so on and so forth, what you will find is that employees under probationary period have less protection, you know. But beyond this protection, beyond this less protection, you will discover that in modern labor law practice, the modern labor law practice requires that employers exercise caution in the management and termination of probationary employment so as to avoid conduct that may amount to unfair practice, arbitrariness, or abuse of contractual discretion. Let me give you a practical example. For example, where assuming the contract of employment is silent on termination procedure. You know, in Ogbonna and Neptune, you do not need to give notice if the contract of employment is silent. But if the contract of employment provides for termination procedure, either as to notice, were usually shorter than compared to full staff, or salary, you must comply. Let's assume a situation where the contract of employment is silent on notice period, and the probationary period for the employee in question is 9 months, and the employee in question worked for, let's say, 6 months. But unfortunately, during that 6 months, the employer failed to appraise, you know, this employee in question, and the employee did not, of course, behaved well, you know, no misconduct on her part, and, you know, on a fresh Monday morning, the employee came to work, and the employer handed a resignation, a termination letter stating that your service is no longer required. You know, of course, looking at the decided case, you can say that, of course, since the termination, since the contract of employment is silent on termination process, then, of course, the employer has acted based on the provision of the law. But when you look at modern day practice, particularly when you start considering the principles around unfair labor practice, the principles of arbitrariness when it comes to termination, the principle of observing basic fairness in termination process, the principle around legitimate expectation interest, because really an employee under probation has a legitimate expectation that if he or she performs well, performs good, then, and behaves properly, of course, there is some form of legitimate expectation on the part of the employee that, of course, I think my employer should confirm me. But unfortunately, the employer terminated the employment in question. So what becomes of the fate of that employee? Does he or she has a right of action in court or not? So when we start looking at this thinking, you know, in modern day employment law practice, we find out that the position is shifting gradually. You know, the position is shifting gradually. Quickly, let's look at the principle around confirmation, deemed confirmation of employment. Deemed confirmation of employment, it means that after the expiration of the probationary period, the employer in question failed to or refused to terminate or confirm the employee in question, but the employee continues to come to work, the employer continues to take benefit from the work done, and Of course, the employee continues to earn salary by law, and it's also a form of protection for probationers as well. That employee is deemed confirmed in law. By the implication of that is that you are now a full staff entitled to all those benefits that I mentioned earlier, which mostly they are contractual. You are entitled to those benefits. And you are this principle by conduct. The employer has confirmed your service, and this principle is rooted in the principle of estoppel by conduct. We all know the principle around estoppel by conduct, where a person, either by his words or by his conduct or representation, made a promise to another on a particular state of affairs, and that person has shifted position. That other person that made that representation or promise will be stopped in law, from denying or refraining from that conduct. So the principle of deemed confirmation is rooted in the principle of estoppel. Now let's flip it the other way around. And I'm talking of a situation where the employee, maybe the employer in question, can actually take benefit of the principle of deemed confirmation. A situation where, although the employer failed to confirm or terminate the employee in question, but continues to, pay the employee in question salaries and other allowances, and let's say the employee in question resigns, can the employer demand for full notice period as a confirmed step, or does the principle under probation, the notice period under probation, still applies? Let's look at this scenario, and I would love to see your beautiful comments in the chat box. Scenario 1, XYZ Limited employs Dayo. His contract of employment provides that the probation period shall be 6 months. The probation clause further provides that either party may terminate the contract during the probation period by giving 1 month notice or 1 month salary in lieu. But upon confirmation of employment, the applicable notice period shall be 3 months notice or 3 months salary in lieu of notice. Dayo worked for XYZ Limited for 3 years. Although he received no formal letter of confirmation of employment, but was paid full benefits and allowances after the expiration of his probationary period. Additionally, his application for annual leave was approved for those years, and leave allowances were paid. Dayo later tendered his letter of resignation and paid his employer 1 month salary in lieu of notice, claiming to be an unconfirmed employee. Do you think XYZ Limited can rely on the same principle of deemed confirmation of employment and insist on 3 months notice or 3 months salary in lieu of notice? I would love to see your beautiful comment in the chat box. Now, let's flip it. Scenario 2. Will your answer be different if after the 6 month probationary period, although no formal letter of confirmation of employment, yet he was not paid full benefits and allowances? I would also love to see your beautiful comments, in the chat box. In conclusion, recommendations for employers, employees, as well as legal practitioners navigating this phase. Firstly, for employers should fix probationary period realistically, based on the complexity of the role, the time required to evaluate suitability, and the seniority or technical demands of the position. Secondly, performance concerns should be identified early, communicated clearly, and documented contemporaneously. Employers should avoid raising performance issues only at the end of probation. Extension should be expressly provided for in the contract, time-bound, justified by clear performance gaps, and ideally supported by a performance improvement plan. Repeated or indefinite or indiscriminate extensions should be avoided, particularly after recent NICN decisions. Employers should act promptly at the end of probationary period by either confirming or terminating the employment contract. Silence or inaction exposes the employer to deemed confirmation by conduct. For employees, they should understand that probation is a two-way assessment. Employees should actively seek feedback during probation, clarify performance expectations early, and document assurances or representations made by the employer. Silence should not be mistaken for approval. For lawyers and advisors, they should draft with litigation in mind. Probation clauses should clearly address duration, termination mechanisms, assessment criteria, and whether extension is permitted and how. Avoid vague discretionary language that courts increasingly distrust. Thank you once again for listening and for participating. Now we'll go to the Q&A session. Thank you once again.
Thank you very much to our facilitator for that insightful practical session. Let me, for purposes of emphasis, briefly highlight some key points that our facilitator discussed. First, we are reminded that probation in Nigeria is purely contractual. There is no statutory definition under the Labor Act, which means that everything depends on how well the clauses are drafted and how carefully they are applied. Second, the facilitator emphasized that probation is a two-way assessment period that is beneficial to both the employer and the employee. For employers, it is a window for evaluating competence and cultural fit, while for employees, it is a period of demonstration and self-assessment. Third, the session explored the concept of inchoate employment and the legal implications of probation, particularly that while probationary employees may not enjoy full confirmation benefits, statutory rights such as wages and workplace protections remain intact and unhindered. Fourth, significant attention was also given to reasonableness of probation. Our facilitator reminded us that both in duration and in assessment, the facilitator stressed that probation must be time-bound, realistic for the rule, and supported by proper guidance and evaluation. And it must not be used as a mechanism for uncertainty or control. Fifth, it was examined that the growing jurisprudence around extension and deemed confirmation, including what the courts have recently heard and their stance regarding failure to confirm within a given period. The key takeaway was clear. Employers must either confirm or terminate within an agreed period, as silence or inaction carries legal consequences. Finally, the facilitator cautioned that while termination during probation is lawful, if done in accordance with contract terms, employers must avoid arbitrariness, unfair labor practices, and discriminatory motives. Overall, today's session reinforces one central message: that probation clauses, as in every other contract clauses, must be drafted and managed with dispute in mind, because dispute may certainly arise from such clauses one day. Thank you once again to our facilitator, and we look forward to the next session in this series as we continue to examine other key clauses in employment contracts. We will now proceed to address the questions that have been submitted in the chat box. Kindly continue to drop your questions there, and we'll take them in sequence as time may permit us to do so. So we'll take the questions. So the first question we'll address today is that someone has asked, are probationers, that is those under probationary contract, entitled to benefits such as HMO during the course of their probation?
HMO, that's health benefits. So when you look at the provisions of the National Health Insurance Authority Act, I think 2022, I'm not sure. I think yes, 2022. It's a act that regulates health schemes, in Nigeria. And when you look at the definition of employee in that act, it defines employee as residents, anyone resident in Nigeria, either in private or statutory employment. And it also includes apprentice. So by that definition and looking at the purpose of that act, the probationers are entitled to that benefit. Yes, they are entitled to HMO. Yes, they are. That's my position on that. They are entitled to benefits.
Okay, thank you very much, our facilitator. Another question is, can an employer demand for medical test or fitness examination, and in what circumstances? I guess that should be during the probation period.
Okay. During of course, generally employers has a right to demand to know your physical and mental state. I think the provision of Section 8 of the Labor Act provides for that, and which must be done by a certified medical practitioner. So employers generally has a right to determine your mental and physical state. They want to know whether you're mentally stable or physically fit, for that job. For example, imagine the aviation sector, for example, and you are employed and the employer did not even test whether you are mentally fit or not. Your guess is as good as mine. So generally, employers has a right to know your medical fitness or your history. But however, for people living with HIV or AIDS, there is a provision in the law for that. I think the HIV and Anti-Discrimination Act also. I can't remember the year. There's a act of the National Assembly to that effect that protects people living with that virus, from discrimination. And what that means is that your employer cannot demand for HIV or HIV test. No. However, it also depends on the sector you are working. If you are working in a sector like, let's say, food and beverages sector, or you are working in a sector in a restaurant or as a chef, those are public health sector. The health of the public is at risk in that in those sectors. So by that, it's an exception to the act, to the protection provided under the HIV Anti-Discrimination Act. So if you are working in those sections, your employer can demand for medical tests in that regard.
Okay, thank you very much. Another question. Does the principle of termination with valid reason apply to termination during probationary period?
Okay, the principle around valid reason. Basically, for probationers, the contract of employment governs your termination process. And I think there is currently a growing jurisprudence also around that area, whether the issue of termination with valid reasons applies to probationers as well, beyond the contract of employment. And if you look at Article 4, I think, of ILO Convention 158, it's to the effect that before employers could terminate an employment, employers need to give valid reasons. And those valid reasons are connected to your conduct or your performance or operational requirements. What do they mean by operational requirements? Basically, based on the business operation of the company, maybe there is a merger, there's a merger acquisition, or there's a redundancy, or there's a winding up, and so on and so forth. So based on this reasoning, the employer can, these are the valid reasons why employers can terminate. However, when you look at Article 2 of ILO Convention 158, you discover that the same ILO permits member states to exclude certain categories of workers from the provisions of the convention. And one of those workers that fall into that categories are probationers. And although there are two different schools of thought in respect of that, but at the risk of sounding academic, I will not want to go into that. But generally, if you look at the committee of expert reports to the ILO Convention 158, the committee of experts report, it's like it's like an explanatory note that explains the thinking behind the convention. So you discover that the committee of experts reports gives employers some flexibilities in the implementation of the ILO convention. And one of those flexibility is the provision of Article 2 that says member states are permitted to exclude certain categories of workers from the application or provisions of the convention. But in doing that, they've said that in exercising that flexibility, employers must be guided by the principle of basic fairness when it comes to termination of employment, because the whole of of Convention 158 is to basically provide some form of, job security, for the employee, and to avoid or prevent the situation of unfair dismissal or termination. So they've come to say that apart from the flexibility provided, employers exercising the discretion under Article 2 must comply, must do that by exercising basic rules of fairness. And when you look at jurisdictions like South Africa and Britain, for example, you discover that, looking through their laws, you discover that probationers generally, they are not placed on the same level with full confirmed staff. They are not on the same level. So, but the fact that they are not on the same level does not give employers the power, the power to just terminate unreasonably, so they must still comply with basic rules. For example, in South Africa, you discover that to terminate employees under probation, employers, when compared to full staff, employers need to, all they need to do is to comply, is to give, the reasons must be less compelling. Yes, it must be less compelling compared to confirmed staff. But when it comes to the procedure to terminate the contract, is the same. For example, you must have give the employee in question, maybe when it comes to dismissal based on poor performance, you must have given notice. You must also give the employee in question time to respond. When you must also investigate the poor performance, and after investigating any report, the employee in question must be obliged with that report, and so on and so forth. So the procedure for both for termination or dismissal under the Labor Relations Act in South Africa is different. Is the same with both for the employee, for probationers and full staff. But when it comes to reasons, it is the reasons could be less compelling. And this is what I mean by less compelling. Let's say, for example, for confirmed staff, it can be a situation of, for example, the reason could be gross negligence. Gross negligence is different from maybe, for example, you are terminating a probationer because of attitude, his or her attitude to work. When you compare both, the reasons for the probation, because for probationers, all you are really assessing is the suitability, the competence of the probationer. And we want to be sure that this person is fit for purpose before onboarding that person into the workplace culture. So you'll find out that in these jurisdictions, they treat, although they place the probationers, they are not probationers and confirmed staff, they are not on the same level, but the fact that they are not on the same level does not mean that you treat them less of a worker, or you treat them less of their rights. Yes, but generally, when you now look at coming back home in Nigeria, looking at some decisions, you discover that yes, that's the same position, that probationers and confirmed staff, they are not on the same level when it comes to rights and benefits. But notwithstanding, looking at modern law practice, you discover that there's this growing jurisprudence that, of course, you have to treat them right. You cannot terminate arbitrarily, and so on and so forth. So I think I would say it is neither here nor there for now. The position is a bit settled. And if you ask for my view, really, let's reason together, because when it comes to even the issue of giving valid reasons or not valid reasons, valid reasons can be connected to conduct, performance, or operational requirements. Okay, for conduct, of course, as a probationer, if you misbehave during probationary period, of course, your employer can terminate your employment. Also, in terms of performance, of course, the whole essence of the probationary period is to also assess your suitability for this role, for fitness for purpose. So you will see that in practical terms, you may discover that there is no really difference in that. But for good practice, I will advise that, because it won't cost an employer, to terminate for either performance basis or conduct basis in that regard. Thank you.
Okay, thank you very much. So I see that there are lots of comments on CPD points. So before we take the next questions, please note that the link to the form for CPD points will be shared in the chat box. So just direct your attention there. Okay, so the next questions, I think the 3 questions I have here seem to be related, so we'll take them together. The first here is that, is the doctrine of deemed confirmation absolute? And the person went further to say, can an employee be deemed confirmed when he or she is being investigated for misconduct? Can the investigation period be taken as freezing the confirmation period to a decision the employee's guilt or otherwise is made? So we'll link that up with the next questions, where this person says, what happens when the contract specifies that there is no confirmation at the end of the probationary period? The employment is deemed terminated, but in this case, can a deemed confirmed employee request for benefits not paid to other staff after the probationary period lapses?
Please come again with the last question.
Say, can a deemed confirmed employee request for benefits not paid to other staff after the probationary period lapses?
Okay, to answer the last question. So once the probationary period, during the probationary period, once the employer in question failed to confirm or terminate your employment, you are deemed confirmed, even if it is 1 day after. I think that settles this. If you follow me during the course of the discussion, you will realize that, you realize that we've actually dealt so much on that point. And by principle of deemed confirmation, the moment you are deemed confirmed, even if it is 1 day, you are entitled to full benefit starting from that day. You are entitled to full benefit as a full staff, whether your employer says gives you formal letter of confirmation or not. So it is by conduct. By conduct, you are deemed confirmed, and it is tied to the principle of estoppel by conduct. In relation to the first question on, Paul, can you please repeat that question? The first question on disciplinary.
Yes. So the person asked that, can a person who is under probation be deemed to be confirmed while he's undergoing investigation for misconduct? And then he went further to say, would that period of investigation be taken to resume the completion period?
Okay, by reasoning, I do not think that that period of investigation will amount to an automatic confirmation of employment. And it also depends on the way and manner the employment handbook is drafted or crafted. So you may need to go back to the employment handbook, particularly on the procedure for discipline, suspension, based on the employment handbook of the employer in question. You may need to go back and do that, because I do not have full facts in relation to this. So I could just be stating the principles here and there, but it all depends on the contract of employment, the employment, particularly the employment handbook, which is extensive in provision for probationers.
Okay, thank you very much. Our next question is the statute of limitation apply to claims for any benefits in probationary period?
Statute of limitations generally, because I think last year or the year before, there were so many arguments as to either whether statute of limitation applies to contract of employment or not. But generally, just note that even contract-wise, you have 6 years to commence an action. Why wait till after 6 years before waking up from your rights, before waking up from your slumber? So generally, in private employment, statute of limitation applies. Statute of limitation applies. So, but for statutory employment, you the Pauper Act, I think you will need to read the case of Okoronko against INEC decided last year, where the Supreme Court dealt expressly deeply on that the Pauper applies to, which you must commence your action within 3 months, applies to statutory employment.
Okay, thank you very much. So the next question is that will the court apply the same standard where the employee seeks to rely on the probation clause in the letter of employment to claim that since he was not confirmed, he was not bound to give the appropriate notice when seeking to quit the employment? And I'll merge that with the next question, where someone says, where no letter of employment is given to the employee by the employer, can that employee leave without notifying his employer, considering the fact that there is no formal contract between them?
Well, for the last question, because the power imbalance, there's power imbalance in employment contract generally. So the weight is usually on the employer. When the employer does it wrong, the employee in question, we blow a trumpet around that. But when it comes to the employee, employers do not, they don't make it an issue. So if the contract of employment is silent on termination, of course you can as well, you can terminate, of course, without giving reason. Look at the case of Ogbonna against Neptune. Of course, that the Supreme Court established that fact. So, but where your contract of employment states otherwise, that you must give notice, or either as to notice as to termination or salary in lieu, then you need to give notice for that period. Please, can you remind me? Okay, the first question, basically, I think the person that asked wants us to answer the scenario question. So for the first scenario, to the extent that the employer has treated the employee in question as a confirmed staff, paying those benefits, as a confirmed staff to that employee in question. The fact that there was no letter of confirmation, which is, I can say maybe for formality's sake, if it comes to equity, must come with clean hands. I believe that the employer in question the XYZ Limited can demand for a full termination notice, which is 3 months compared to the first one. But as regards the second one, of course, and of course, still on the first principle, there's this saying that what is good for the goose is also good for the gander. So to the extent that the employee can took the advantage of the principle of this confirmation, I think the employer can also do that, provided since the employer in question has done the needful. But in flipping it, for the second scenario, to the extent that the employer in question failed to, although the employee is deemed confirmed in law, but the employer still treats that employee as an unconfirmed staff, those benefits, he or she has been denied of those benefits. I do not think, the employer can rely on the principle of deemed confirmation. Of course, still on the principle, if it comes to equity, must have done equity, must come with clean hands, and so on and so forth. And also, there's also the principle that employer should not be allowed, to take, to benefit from their own wrong. So because the employment contract, the probationary contract period is rooted in contract, that principle also emanated from contract. So that answers the question.
Okay. So can an employee under probation be held liable and sanctioned for causing loss to the employer?
Absolutely. 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 Absolutely.
The other questions here. Okay, this person says, probation is entitled to pension.
Of course they are. They're entitled to pension. Pension is statutory. is statutory, so they are entitled to pension.
Okay. Next question. He said, what are the salient things an employee have to consider when he desires to make an employee a partner? I think this question is very technical, except you want to try otherwise. Okay, that way you want to make somebody a partner, what things are you supposed to consider?
I think that's based on the personal arrangements, personal arrangements between the person and yourself. So it's at your discretion, really. Nothing, no legal principle around that. Probation.
Okay. What happens when the contract specifies that where there is no confirmation at the end of probationary period, the employment is deemed terminated? But in this case, both the employer and employer are silent after this period as the employee continues to work and the employer continues to enjoy the benefits of work done by the employer.
They are deemed confirmed. They explain that principle during the course of presentation. Where the employer fails to either confirm or terminate, the employee in question is deemed confirmed, and all benefits accrue to that employee from that date.
What if I argue my employer for extension because I don't want to go back to the labor market? Is that legal?
Well, I would say yes, but it depends. Looking at the contract of you have to look at the contract of employment. Does the contract of employment provides for extension? And if it provides for extension, no problem. But we've also looked at the issue around, because it's easier said than done. For employees to say, oh, I agree to this, and let's continue with the employment contract. What if along the line, the relationship, became sour, becomes sour? Although that is when some of these principles begins to come up. So I think for safety for the employer, if the contract does not permit extension, please do not extend. And like I said, because of the recent decisions of the NIC nullifying the practice of extension of probationary period, you may not, because of the legal risk, pending when the Court of Appeal will clarify that, you may not want to risk it. And if you want to determine probationary period, in advance, for this, for the particular employee in question, like I advised, you factor in the possibility of an extension, of course, based on the principle of reasonability that we mentioned earlier. I think that answers that.
Okay, yes, so I think this person needs a clarification. He says, did I hear you say that an unconfirmed employee, if he desires to withdraw his service, must give a 3 months notice?
An unconfirmed employee. Okay, based on the scenario. So for the fact that, so in the first scenario, it was not confirmed, but you enjoyed the benefits. You enjoyed the leave allowances. You enjoyed the bonuses. You enjoyed, all other benefits, that accrues to full staff. I believe and I think that the employer can demand full notice, because it who comes to equity must come with clean hands, must have done. Because really, if you look at it practical wise, what the employer failed to do is that letter of confirmation. But it's like the former letter of confirmation, but the employer has done the needful by treating you as a full staff. So I think the employer can demand full notice period for 3 months compared to 1 month.
Okay, thank you. This question, can an employee who is yet to be confirmed and is now doing NYSC, still under same employer, be confirmed. So that merges with the other question. Are NYSC corpers, core members were entitled to, can they be deemed probationers?
I'm aware that I think under the NYSC Act, there is a provision that says before there's a condition before an employer in Nigeria can employ anybody or any worker, the employer must ensure that the employer must ensure that the employee, the worker, has a, I think either certificate, NYSC certificate, or discharge or exemption certificate. So that exemption certificate or NYSC certificate statutorily, it's a condition precedent that an employer must fulfill before employing a worker. In other words, what I'm trying to say in essence is, by that provision, I do not think, because the law by statute has made NYSC certificate, or discharge certificate, which are usually issued at the end of the NYSC certificate. I do not think that you can be a probationer at that point, because really, until you present that certificate, you are not yet, I stand corrected anyway, but I do not think that until you present that certificate, you are not yet, I do not, for the sake of, for lack of a proper word, you are not yet a worker, but it doesn't mean that you are not entitled to certain benefits. So that being placed on a probationer, it means that your employment has commenced, has started, It means that before that can be done, you must have presented your NYSC or exemption certificate to that effect. And that you cannot be a worker until that is done. The fact that you cannot be a worker until that is done, then before that phase, you cannot, I don't think, for lack of better word, that I said, you cannot be a full worker, in quotes. At best, you can only be an intern for it, because even the NYSC says, there's a provision in the NYSC Act that says that the employer should ensure that core members gain full experience during that process. So it's more or less like an internship process, like a learning process for NYSC core members at that point.
Okay, so due to time, we take just this one more question. And it says, is length of probation provided in the labor laws, or is it at the discretion of the employer?
Like I said, if you follow us during the presentation, the Labor Act is silent on probationary period, and it is primarily rooted in contract. And during the course of the presentation, we also went ahead to show you how, even though it is contractual, that employers should not exercise that discretion in contract. It's not subjective, it's objective, and we went to South Africa and we analyzed how the duration for probationary period should be determined. So in Nigeria, for example, even though the Labor Act is silent on that, we want to consider things like the nature of the job, the skills required for the job, what are the industry practice, the experience, or or sometimes the qualification of the employee in question, to determine the appropriate probationary period. Thank you.
Thank you. That will be up for the questions. Please, you can continue to drop your questions an email address will be shared, or you can to the facilitator privately. Thank you very much for the engaging questions and contributions in this session. The quality of discussion here reflects the depth of interest in this topic, and we truly appreciate the thoughtful participation from everyone. On behalf of Simmons Cooper Partners, I would like to sincerely appreciate the Nigerian Bar Association Institute for Continuing Legal Education for collaborating with us to facilitate this session, and for their continued commitment to advancing practical legal education. We also extend our gratitude to our senior colleagues, respected members of the bar, and all participants who took time to join us today. Your presence and engagements are what makes sessions like this truly meaningful. This concludes the first session in the series, and we look forward to welcoming you again as we continue examining other key clauses in employment contracts in the subsequent sessions. Please, for our CBD point, you all registered for this, and it will be collected automatically. So there's no need for us to fill any form. That information, you can also see it in the chat box. For want of time, we may not be able to answer all questions. If you have additional questions after this session, you may send them to the email address that is shared on the screen, or you may reach out to the facilitator directly via LinkedIn. Thank you once again, and we hope to see you at our next session. Have a pleasant day. Thank you.